Jai Hind to all of you. Myself Updesh Kumar Jaiswal, working as an assistant professor in Department of Computer Science and Engineering, Ajay Kumar Garg Engineering College, Ghaziabad. The topic of my today lecture is arbitration and law at workplace. It is related to subject Constitution of India, Law and Engineering. Subject code is KNC 501. Arbitration and arbitration law in India. Firstly, we should understand about the arbitration. The dictionary meaning of arbitration is the process of solving an agreement between by helping them to agree to an acceptable solution. Arbitration is a part of alternative dispute resolution mechanism that benefits parties who want to avoid the normal lengthy recourse of the local courts for the settlement of disputes. It is in fact a legal technique for the resolution of dispute outside the court, wherein the parties to a dispute refer it to one or more persons, namely arbitrators, by whose decision they agree to be bound, and their decisions are called as the award. It is considered as international commercial arbitration where two parties from two different countries approach an international arbitrator, either by their mutual consent or through an arbitration institution, and resolve their disputes accordingly. It is at the international level. Arbitration is the dispute settlement process between two agreeable parties to appoint an arbitrator to give a binding solution on their dispute. It is a way to settle disputes outside the court. It is very important to note, thereby saving time. It saves the time and resources. Arbitration is a legal mechanism. It is a legal mechanism encouraging settlement of disputes between two or more than two parties mutually by the appointment of a third party whose decision is binding on the parties referring the said dispute. And then third party is called as the arbiter. So arbitration is a process in which a dispute is submitted to an impartial outsider arbitrator who makes a decision which is usually binding on both the parties. It is the first party, it is the second party, and here it represents the arbiter who will provide the award about their dispute finally. The arbitrator enforces his own point of view on the contending party, and the opinions of the participants are not given any predominance. Arbitration is a judicial process. It is a judicial process, and court will also recommend this. The award of the arbitrator is the binding. I already told, award is the decision. Is binding and rest and equity and justice. That is, there is no scope for compromise. Here in this diagram, I have shown all the arbitration process. Firstly, case is filed, then arbitrator selection process. In third stage, preliminary hearing and scheduling order. Then discovery process. It is the fourth stage. Hearings or mediation. Arbiter are also called as the mediator. Arbitration hearing. Post arbitration briefs, and then finally final arbitration award, that is called as the decision given by the arbiter in case of dispute between the two parties. So there are major 8 steps which are involved in the arbitration process. Arbitral dispute. This type of dispute coming under the category of arbitral dispute, where arbitration process can be used by the arbiter. Property related, insurance, contract including employment contracts, business partnership dispute, family dispute, except divorce matter, construction, commercial recoveries, and many more. Non-arbitral dispute matters of criminal nature. It is not solved by any arbitration process. It is only solved by the court, and court will give the decision. Disputes relating to matrimonial relations. It is also decided by the Civil Code of India. Testamentary matters relating to the validity of a will, relating to trust for public purpose of charitable or religious nature. Insolvency matter relating to guardianship of a minor person, any execution proceedings. These are not solved by the arbitration process. Duties of arbiter. Arbiter or mediator is very important, and his duty is also, we should know, to administer the oath to the parties and witness appearing, to act judiciously and impartially, to put necessary interrogatories to any party to the dispute, to determine by and to whom the cost of the reference and the award shall be paid, to award interest, to fix amount, mode and time of payment. These are the different duties performed by the arbiter. The law governing arbitration. To determine the rules of law applicable to dispute, the law makes a difference between the domestic arbitration and international commercial arbitration. Under international commercial arbitration, the court must apply the law of land where the dispute arises and as agreed by the party, and in case of failure to do so, the tribunal must apply rule of law considered appropriate as per the circumstances. Indian courts have accepted long back that in case of absence of any arbitration agreement, the arbiter can apply the law which is most closely connected and relevant to the subject matter in dispute. So this authority is given to the arbiter. However, the Indian tribunals are obliged to apply substantive law where the parties are Indian. Further, the tribunal can grant award as it deems fit and may pass the interest from the day of arising of the cause of action till the arbitration award has been granted and is seemed reasonable. So, what is the advantage of arbitration? The first advantage is choice of decision maker with expertise. Speed up the process of judgment. Cost will be low, very flexible, confidentiality because both parties are involved, less formal than court. In courts, more formality is required. Here, less formality is required. Presentation of business relationship. So these are the major advantages by the arbitration process. And there are some disadvantages of arbitration also. There are only limited resource. 3 persons are present, first party, second party and arbiter. So limited resources are there. Uneven playing field, lack of transparency because both parties are sitting face to face. Parties pay for arbitration to the arbiter and agency. Limited rights of appeal, fewer means to challenge award, lack of formal discovery. So these are the disadvantages of arbitration process in India. Now, laws at workplace. we are working in some company, some organization, some factory. So we should know what are the different law which are applied at the offices, enterprises, workplaces. So laws at workplaces in India we should understand. Industrialization is considered to be one of the key engines to support the economic growth of any country. Business, factories, industry are considered to be one of the key engines to support the economic growth of any country. In any country, India is also. The commence of industry and its growth is not a venture of the employer alone. It involves the hard work and tough grind of each and every stakeholder of the industry, including the laborers, supervisors, managers, and entrepreneurs. Many labor's law have been established to ensure improvement in health, safety, and welfare of the workers, welfare of the employee, to protect the workers against some negative terms, as individual workers is economically weak and has little bargaining power, to encourage and facilitate the workers in the organization, in the office, in the factory, to deal with industrial dispute, to enforce social insurance and labor welfare scheme and alike. The very important act which are applicable in India is the Factories Act 1948. It explains provision for the health, safety, welfare, and service condition of the workmen or employee working in factories. It contains provision for working hours of adults, employment of young persons, leaves, overtime, etc. It applies to all factories employing more than 10 people and working with the aid of power, or employing 20 people and working without the aid of power. It covers all workers employed in a factory premises or boundary line directly through an agency, including a contractor involved in any manufacturing company. Some provisions of the Act may vary according to the nature of work. Now, some major provisions of the Factories Act are explained below. I am going to explain. According to Section 11 of the Act, it provides that every factory should be kept clean and free from foul smell arising from any sewer, drain, or other nuisance. According to the Section 13 of this Act, it focuses on ventilation and temperature maintenance at workplace. Every factory should work on proper arrangement for sufficient ventilation and circulation of fresh air. Section 18 of the Act specifies regarding agreements for sufficient and pure drinking water for the worker, because drinking water is very important at any workplace, and it is also important for the human being. Section 19 further mentioned that in every factory there should be sufficient accommodation for urinal, which should be provided. It should be kept clean and maintained. Bathroom, washroom, urinal are important. According to Section 21 of the Act, provides from proper safeguard of machinery, and that any moving part of the machinery or machinery that is dangerous in kind should be properly placed. According to Section 45 of the said Act, specified that every factory should have properly maintained and well equipped first aid box. There should be first aid box in every factory, or almirah with the prescribed contents. For every 150 workers at one time, there shall not be less than one first aid box in the factory. If suppose there are 300 workers, then there should be 2 first aid box. Also, in case where there are more than 500 workers are working in the factory, there should be well-maintained ambulance service, and a room should be there where patient can take the rest. It should be of the prescribed size and containing the proper facilities. The Employees Compensation Act 1923. Earlier it was known as the Workmen Compensation Act 1923. This act was come into the picture in year 1923. It aims to provide financial protection to workmen and their dependency in case of any accidental injury arising out of or in course of employment and causing either death or disablement of the worker by means of compensation. Suppose there will be some accident, and in accident death or some disability will come to the worker. This act applies to factories, mines, docks, constructions, plantation, oil fields, and other listed in Schedule 2nd and 3rd of the discussed act, but excludes covered by the ESI Act. This act provides for payment of compensation by the employer to the employees covered under this act for injury caused by the accident. Generally, companies take insurance policy to cover their liability under the EC Act. So, insurance facility is given by the organization to the employee. Individual insurance or group insurance are applicable. Weekly Holiday Act 1942. It provides for the grant of weekly holiday to person working in shops, restaurants, and theaters. The act provided every shop shall remain entirely closed on one day of the week. Which day shall be specified by the shopkeeper in a notice permanently in a conspicuous place in the shop. Notice will be given on which date shop will be closed. Further, the state government may require in respect of the shops or any specified class of shop that they shall be closed at such hour in the afternoon or 1 week day in every week in addition to weekly day off, and it is decided by the state government like UP, Bihar, and depend upon them. Payment of Wages Act 1936. The Payment of Wages Act 1936 is a central legislation which has been enacted to regulate the payment of wages to workers employed in certain specified industries and to ensure a speedy and effective remedy to them against unauthorized deduction or unjustified delay caused in paying wages to them. If they are getting salary less or salary late, then this act will be applicable. It applies to the person employed in a factory, industrial, other place, or in a railway, whether directly or indirectly through a subcontractor. The main objective of this act is to eliminate all malpractices by laying down the time and mode of payment of wages and by securing that the workers are paid their wage at regular intervals without any unauthorized deduction. In salary, there should be no deduction. Minimum Wages Act 1948. The Minimum Wages Act empowers the government to fix minimum wages for employees working in specified employment. It provides for review and revision of minimum wages already fixed after suitable interval, not executing 5 years. After every 5 years, there should be some amendment. It extends to the whole of India and applies to scheduled employments in respect of which minimum rates of wages have been fixed under this Act. The appropriate government shall fix the minimum rates of wages payable to the employed in a scheduled employment. It may review at such interval not exceeding 5 years the minimum rates of wages so fixed and revise the minimum rates if necessary when required. The employer shall pay to every employee in his scheduled employment under him wages at the rate not less than the minimum rates of wages fixed under this Act. This Act also provides for regulation of working hours, overtime, weekly holidays, and overtime wages. Duration and payment of wages, deduction from wages are also regulated. The Act also provides appointment the authority to hear and decide all claims arising out of payment less than the minimum rates of wages or any other payment due under this Act. The presiding officer of the Labor Court and Deputy Labor Commissioners are the authorities appointed to handle these matters. So, these are the different resources which I have used while making this lecture. 4 textbooks, 3 websites, and 3 journals are used by me in making up this lecture. Thank you and Jai Hind to all of you.